found under Family Law Code Section 3104, and you got to go through 3 different things that you have to prove to the court to secure your grandparents' rights. Again, you can see 3 different things you have to go through. If it's during a divorce action, all you have to prove is one thing: it's in the best interest of the child. So the 3 requirements that you have to go through when there's a divorce that's already taken place and now the grandparent is coming out of the woodwork and saying they want some sort of visitation rights would be: the first thing, you have to show a bond. You have to show that there was a pre-existing relationship with the grandchild, and that it would be in the best interest of the child to continue that relationship. If you don't have a bond, you have no rights. So, I mean, there has to be a bond created to secure rights. So if you get a situation where even, say, mom was pregnant and you're going to be a new grandparent, but you haven't actually met that child yet, no rights. So you have to show a pre-existing bond to make it keep going. So if you can show that bond, then you move on to the next prong. The next prong is a balancing test where the court weighs what is in the best interest of the child versus the parent's right to exercise their parental authority. So in a situation like that, the courts will look at, well, why is the parent exercising that parental authority to deny that visitation? And really, they want to see a good, strong reason, i.e., the grandparent is an alcoholic, the grandparent has abused me when I was growing up, or the grandparent even hit the grandchild, spanked him, something like that. Then the court might say, well, the parent maybe does have a right to decide in this situation. But if the parent doesn't have a big issue like that, then the best interest of the child is going to outweigh that right to be with the grandparent, because it definitely is in the best interest, if there's no other issues, to have more family in your life and to have as much love as possible. So, if you can get over that hurdle, then you get to the last hurdle. And this is the most confusing one, but you can get through it and around it, and it's Family Law Code Section 3104F, which states there's a rebuttable presumption that visitation with the grandparent is not in the child's best interest if one parent doesn't agree that grandparent visitation should be granted. So again, there's a rebuttable presumption that if one parent says no, the court should listen to that and say no. But what a rebuttable presumption is rebuttable. So it just means when the judge starts his analysis on this particular issue, he's going to think the parent is right. I'm going to start my thinking with the parent's right here, and now let's see if the grandparent can rebut that presumption and prove that no, the parent's wrong and it's actually in the best interest of the child to still maintain visitation with me, the grandparent. So if you can get through all 3 of those, that would be the last test, then you actually secure your rights. So if you can get around that rebuttable presumption and prove, and again, the rebuttable presumption, they're going to look at bond. Do you have this strong bond? And they're going to look at, again, the parental authority on why is this parent saying no? And unless it's a good reason, they're going to allow that bond to keep going. So unless you have a serious issue where the grandparent has, criminal convictions, again, alcoholism, child abuse, they're going to allow that bond to continue. So 2 actual last things that are very important here is when you're pursuing these cases, grandparents definitely need to be aware that if they secure their grandparents' rights, they can have to pay child support. And also, if a grandparent is deemed to have a lot more money than the mother or father involved in the case, they can have to pay for the attorney's fees. And that's it. So.